Good afternoon, everyone. I'm Debbie Schrager. I am the director of Georgetown Law's Supreme Court Institute. I'm very pleased to welcome you to this afternoon's event. The Supreme Court Institute offers moot courts as a public service at no charge and irrespective of the positions taken by counsel, reflecting a core commitment to the quality of Supreme Court advocacy in all cases. In recent years, SEI has advanced that goal by conducting moot courts for advocates in nearly every case on the court's argument docket. In the most recently completed term, October term 2020, SEI provided a moot court for advocates in all but one argued case. We are very happy to sponsor this panel discussion about one of the most significant cases that the court will hear in the current term. I'd now like to introduce William Treanor, Dean and Executive Vice President of Georgetown University Law Center and the Paul Regis Dean Leadership Chair, who will serve as moderator for today's event.
Well, thanks very much, Debbie. And it's a privilege to be here. And I'm glad to all of our panelists and our audience that you've joined us today for our program on New York State Rifle and Pistol Association versus Bruen, which concerns the scope of the Second Amendment's right to carry firearms in public. The case will be argued before the Supreme Court on November 3rd. And as Debbie indicated in her introduction, it's unquestionably one of the most significant cases of the court this term. As most of you probably know, in District of Columbia versus Heller, the Supreme Court held that the Second Amendment gives an individual a right to possess a firearm in the home for purposes of self-defense. The court left open the question of the extent to which states and the federal government may restrict carrying firearms in public. This case raises that question in the context of a New York statute that requires a special license to carry a firearm for purposes of self-defense outside the home. Certain classes of people, such as merchants, may carry a firearm in their place of business. Others may obtain a self-defense license only if they can demonstrate a quote-unquote proper cause, in the words of the statute. The question presented is whether New York's good cause restriction violates the Second Amendment. And to discuss that, we have really a remarkably distinguished panel. Richard Bernstein is a pro bono appellate lawyer specializing in issues that raise questions of separation of powers and federalism. He previously was a partner at Wilkie Farr and Gallagher and Sidley and Austin, and a clerk for Justice Scalia and Judge Amalia Kearse. He's filed amici briefs in the Supreme Court addressing gun carry restrictions, efforts to overturn the 2020 presidential election results, and unilateral actions by the executive branch. He's been appointed twice by the Supreme Court to argue cases. We're also joined by Professor Robert Cottrell. He is the Harold Paul Green Research Professor of Law at GW Law. He joined the law school faculty in 1995. Previously, he taught at Rutgers and Boston College, and he had visited at the University of Virginia. Cottrell is a specialist in American and comparative legal history, and he also teaches criminal law. And he's also professor of history and sociology in the Columbian College at GW University. Professor Cottrell's writings on law and history have appeared in the Yale Law Journal, the Georgetown Law Journal, the Boston University Law Review, the Texas Law Review, American Quarterly, and the Latin American Research Review, among other journals. We are also joined by Robert Leiter. Professor Leiter is an assistant professor of law at Antonin Scalia Law School, George Mason University. He teaches criminal law and torts and has written on the law of self-defense, constitutional allocation of military power, and gun control. Before joining the Scalia Law School, Leiter clerked for Judge Diane Sykes of the United States Court of Appeals for the Seventh Circuit and Justice Clarence Thomas. Leiter earned a BA, summa cum laude, from the George Washington University, a JD from Yale Law School, and a PhD in philosophy, dissertation defended with distinction from Georgetown University. And finally, we have our own Professor Mary McCord, Executive Director of the Institute for Constitutional Advocacy and Protection, ICAP, and a visiting professor at Georgetown Law. Professor McCord was the acting assistant attorney general for national security at the Department of Justice from 2016 to 2017, and principal deputy assistant attorney general for national security from 2014 to 2016. Previously, she was an assistant U.S. attorney for nearly 20 years at the U.S. Attorney's Office through the District of Columbia. Professor McCord graduated from Georgetown University Law School and served as a law clerk for Judge Thomas Hogan of the United States District Court for the District of Columbia. It's a remarkable panel, and I look forward to this conversation. So let me start, and I'm going to ask the first question for Professor Leiter. One question that I'd like to throw out to everyone, and again, beginning with Professor Leiter, is whether in deciding what restrictions may be placed on public carry, should we be focused on whether New York's restrictions are consistent with framing error restrictions? Or is it possible to argue that the public safety risks that exist today from unrestricted public carry are so different in degree from the risks during the framing era that framing error restrictions do not establish the limit on what restrictions may be imposed today? So let me start. Robert, let me start with you.
Yeah, thank you, Dean Treanor, and thank you for the opportunity here today. So it depends a little bit on what you mean by framing error restrictions. So if you're looking at the time right around the time the Constitution was adopted in the late 18th century, there just weren't many regulations on public gun carry. And so there's nothing to compare it to. There are a handful of statutes that prohibit, that codify the common law prohibition against going armed to the terror of the people. They all require that it be done to the terror of the people. They were not simply bans on public carry. To the extent that today people dispute that and say, well, no, it was inherently the act of carrying a gun that was terrifying. But more basically, we have no cases about these laws. There's no evidence that these laws were ever enforced. And so, we have nothing if we're going to go right around 1791, when the Second Amendment was adopted, there just wasn't any robust public carry regime at all. In the United States, the real regulation of public carry begins in the 19th century as the southern states passed laws against carrying concealed weapons. And here, I think the risks are fairly similar, if slightly different, from what happened in the early 19th century. So a lot of the early 19th century laws were aimed against dueling. Those types of motivations have receded into the imagination. But in terms of when you look at the effects, the harms caused by gun violence, the harms are really interpersonal conflicts. They're, most deaths are single deaths involving either heat of passion killings or organized crime activity, or gang and drug conflicts and the like, but it's primarily single homicides committed with concealed or concealable weapons. And so from that end, the early laws against concealed weapons remain with us, and I think remain very relevant. If you look at the toll taken by gun violence today, it's almost all with handguns. And it's almost all one homicide or two homicides. It's not the mass shootings that often capture the public horror because of their press coverage. So if you're comparing it to the early 19th century, I think that the regulations and the underlying things that motivate the regulation in terms of controlling crime are actually quite similar. But if you're looking at 1791, there's just not much to compare it to.
Okay. And actually, let me just say, as we're going through, if anyone from the audience has a question for the panel, please send them using the Q&A function. And I'm going to try to save time for a few questions at the end for our panel to respond. So, Richard, do you agree with Robert?
No, I disagree on all accounts. The statutes read very differently than he said. I do believe both the English and the founding era statutes are important, however, for two reasons. One, the texts of those statutes show that public carry issues were for legislative authority to decide in light of legislative assessments of the risk. As Justice Barrett has said, it's not the burden of those today supporting a gun restriction to find a mirror image statute in the founding era. what you're looking at, what the question is was the category of public carry a category, unlike home possession, that the legislature could regulate? And there were lots of statutes that regulated it. Some mandated public carry. Others banned all public carry without any exceptions, without any reference to terror of the country. And I would urge folks to look at page 12 of the Judge Ludig amicus brief, which goes through those language. So the second reason it's important is the core of the petitioner's case is an English case in 1686 called Knight's case. And there are a lot of reasons why Knight's case doesn't control here, and it's terse and it's opaque. But here's a really important reason if you're a textualist. Knight's case begins by misquoting the statute. The following is in quotes in Knight's case. Knight's case says the offense is, and it purports to be quoting the statute, quote, from going or riding armed in a fray of peace. That phrase never appears in any statute. It didn't appear in the statute of Northampton, which is purportedly being quoted, and it didn't appear in any subsequent statute. And the whole premise of originalism is that originalists are textualists. Professor Leiter, in his brief, unlike Knight's case, quotes the statute correctly. And what the statute says is, it refers to in a fray of the peace, but for a different offense, for offense of bringing no force. The offense that's at issue in this case is nor to go nor ride armed by night nor by day in fairs, markets, nor in the presence of the justices or other ministers. And then here's a critical part, also not quoted in Knight's case, nor in no part elsewhere. So that puts the burden on folks who say these statutes are unconstitutional to say, well, sure, Knight's case misquoted the statute it was purporting to apply, badly misquoted it, mangled two different offenses, but it applies anyway because Americans thought that was the law. Point one, there was no American treatise in the founding era that cites Knight case. Point two, this is why the American statutes are so critical. If they were following Knight's case, they would adopt the misquote from Knight's case of the Northampton statute. None of the 7 American statutes do that. None of the 7 American statutes say armed in a fray of peace. Zero. They say things like the New Jersey statute. No planter shall ride or go armed with sword, pistol, or dagger, period. So the notion that there were no statutes is incorrect. The statutes in the United States were very different than the statute misquoted in Knight's case. And it's a canon of interpretation. When the language of a second statute is different than the language purportedly in a first statute, the second statute means something different. And what the founding era statutes show is that the question of how much risk is too much risk. Should we ban guns? Should we ban guns only in certain circumstances in public places? Should we ban guns only in certain public places? That's a legislative decision to make. That was true at the time of the founding, and it's true today.
So I'm going to go to Bob in a second, but just so I understand. So Robert, are you saying that there are no founding era statutes that regulate the right to carry? Is that?
There was a New Jersey statute that predated the English recognition of the right to bear arms that did prohibit carrying pistols, but that was it. The rest of the statutes prohibited carrying arms in terror of the country. And I'm looking at page 12 of Richard's brief. There was a North Carolina statute that he cites, but that wasn't actually a real statute. That was a misprint from the person who was codifying it. So no, there were not laws governing public carry, which is why in the 19th century, when legislatures started taking this seriously, they passed laws against the carrying of concealed weapons. If there were already common law crimes, you would have just seen them enforce the common law crimes, but they didn't. They did two things. They passed separate statutes that governed concealed weapons, and they restricted in the South slaves and free blacks from possessing and carrying weapons. And you can't make sense of those statutes if you think that the common law had already prohibited, where there were statutes already prohibited public carry everywhere. So no, there were all the statutes said in terror of the country, except for this one ancient New Jersey statute.
Okay. So, and then, and
Sorry, but that's wrong.
kind of framing the discussion. Okay. So we've got kind of a fundamental disagreement between Rich and Robert on kind of what the nature of the law was prior to 1791 in the United States. Now, let me go to you, Bob. What are your thoughts?
Yes, thank you. I'd like to add some methodological complicators, and perhaps that's what happens when you spend too much time over the School of Arts and Sciences. First of all, I would suggest that when we talk about the founding era, that we should also consider not 1791 exclusively as the founding era, but also 1866 to 1868. We're in part dealing with the 14th Amendment and the determination of those who drafted that to apply the Bill of Rights to the states, including the Second, or I might say especially the Second Amendment. So I think any discussion of the Bill of Rights should see it through the funnel or the lens, if you will, of the 14th Amendment and that particular era. I think also one of the things that we have to consider is that our notions of how rigorously rights should be enforced were somewhat different than the 18th and 19th century versions of that. All I think we need to consider is, for example, the Alien and Sedition Acts. The people who passed the First Amendment also enact the Alien and Sedition Acts, which any court today would look at and say was, in fact, unconstitutional. So we have, I think, what was meant by, we can't go by necessarily contemporary practice as a guide to what the right was meant to mean or how strongly we should perhaps look at it. And also, I think this is particularly true because, of course, the statutes that are being, both speakers are debating are, of course, way before there's any thought of incorporation of the Second Amendment, so that we're simply dealing with either state provisions, constitutional provisions, or in fact, the common law, and not in any way an interpretation of the Second Amendment. Let me also throw something out that we might consider about the premise of the question that, okay, we have 1791 and there were certain dangers from public carry in 1791, but now we're facing something totally new because of technology and urbanization and so forth. That might be good, a good premise, except we've had an experiment for 30 years with liberalization of concealed carry throughout the nation, including in crowded urban areas, Philadelphia, Houston, Atlanta, et cetera. So if in fact contemporary danger is something that has to be added to the consideration, we've already been doing an experiment with liberalized right to carry throughout the nation, of which New York is something of an outlier. But we certainly have to take those experiences into account if we're going to answer the question that you've raised. What about changed contemporary circumstances?
Okay, so let me go back, and then I want to return to Mary in a second. Mm-hmm. So is your first point, Bob, that we should look at not what the understanding was at 1791, but what understanding of the right to bear arms was, at the time of the adoption of the 14th Amendment.
Both, not one exclusively, but we have to add the 14th Amendment experience and history into our discussion.
Okay, now, as I heard Robert and Rich, were disagreeing about kind of the founding era. But Robert, as I was hearing you and as I read from your brief, is, that there were restrictions after 1791, not uniform, but in some states on the right to carry. So does that mean that, if we're looking through the framework of the 14th Amendment, that actually is good for New York State as opposed to the petitioners? In other words, the backdrop of the 14th Amendment is you had state regulations, state restrictions on the right to carry.
Well, Justice Kavanaugh in Heller 2 said that you look not only at the history at the time of the founding, but also the tradition since then. So if one follows that view of the history and tradition test, the 19th century statutes are helpful to sustaining New York, among other things. The 1836 Massachusetts statute that Professor Leiter quotes expressly says that a pistol is a dangerous weapon. And I think there's general agreement that there were allowed to be restrictions on dangerous weapons. But those 19th century statutes grow out of, and the earlier statutes that are cited in our brief, 4 of which, at a minimum, do not say in terror of people. And just one word briefly in defense of the North Carolina compilation. The North Carolina compilation says it's a compilation of the laws existing in England that are considered in effect in North Carolina. And that was 1792. And to give the North Carolina compilation its due, it quotes the statute of Northampton perfectly rather than rewriting the statute like the quote in Knight's case does. So I don't think you can throw the North Carolina statute out or the New Hampshire statute in the 1690s or the Tennessee statute in 1801, all of which use broader language than what Professor Leiter is saying is the requirement.
Okay, so I'm going to give you a chance to respond to that, Robert, and then I want to go to Mary. But let me just kind of frame. So, one dimension that we've started off with is, a fundamental disagreement about what the history shows. So, what was the state of the law in 1791? Rich and Robert take very, different positions. And then another question, which I think Bob has placed on the table is, what is our understanding of the 14th Amendments, the text at the time of the 14th Amendment? How does that alter the approach? So let me go to Rob, and then I'm going to go to Mary. And Mary, I'm particularly interested. The second point that Bob made that I'd like you to talk about is, he's focusing on the question of, is the world of guns so different today that, we should re-examine, what the scope of the Second Amendment is rather than relying on the original meaning. So I'll get to that in a second. But Robert, do you want to talk about the history a minute before I get to Mary?
2 quick things, and I'll keep it very brief. On the North Carolina side, North Carolina was not enforcing an English statute; it was enforcing the common law. And when the North Carolina Supreme Court dealt with the common law in 1840 in a case called State versus Huntley, it said what I have been saying, which is that to sustain a prosecution for going armed to the terror of the people, it has to be done to the terror of the people. It can't be, it said the mere carrying of firearms for any lawful purpose of business or amusement was constitutionally protected. And this gets to my second point, which picks up on what Bob was saying. I think you absolutely have to consider the early 19th century history, because you have to keep in mind that the legal recognition of the right to bear arms around the framing was fairly new. It had come up in England in 1689 with the English Bill of Rights. And it was, only recognized in American constitutions, state constitutions, beginning in the 1780s. So there wasn't a lot of judicial development about what the right to bear arms meant. That liquidation took place in the early to mid 19th century. And when you look at the cases that come out in the 19th century, they don't support New York's position. You have to read them carefully. But when you, read them very carefully, yes, they support, a lot of government regulation, but they also say there's an upper limit. And the upper limit is when you are completely banning somebody's opportunity to carry a gun in public, including for purposes like self-defense. And when you look at New York statute operates as a de facto ban for most of its population who aren't eligible for a license. And so it's not a scheme that's consistent with the way the right to bear arms liquidated in early American history.
Okay, good. All right. So again, we have three different approaches that really focus in on the history. But again, I think Bob has asked, as well, what's the state of play today? And, do the changes in arms suggest we should reinterpret the Second Amendment? Though you've also indicated, I think, that the answer is no. Our experience with, regulation of the right to carry indicates that it doesn't, in fact, promote safety. So, Mary, what are your thoughts? And again, you wrote an amicus brief for our Institute for Constitutional Accountability and Protection. So what's your take on, should we be focused on the original understanding, or is there should we be looking at current circumstances?
Well, I think both. And I think that's what text history and tradition is about, depending on, how far that tradition extends. I think that a lot of this dispute between Professor Leiter and Professor Bernstein sometimes comes down to how do we define the question about what regulation existed, right? Because I think, and what I took from Professor Leiter's answer just to the previous question was he would agree that the carrying of firearms has been regulated. It's been regulated all the way back to the Statute of Northampton. So it's not like gun regulation is something new or that there was none of it at the founding. I think it's about this question. In many ways, this question is about a dispute over what it means to go armed to the terror of the people and how determinative that is about not only what the laws were at the time of the founding, but how should we think about that today? And so I think in some ways that's what brings us to today. And I would also reflect on Judge Kavanaugh when he was Judge Kavanaugh, before he was Justice Kavanaugh, in his dissent in Heller 2, which is the case that went back, came up through District of Columbia after the first Heller decision, when the District of Columbia had made some revisions in light of the first Heller decision. One of the things that Justice Kavanaugh pointed out was that even in Heller 1, the Supreme Court had made clear that concealed carry prohibitions on concealed carry weapons were lawful under most early 19th century court interpretations of the Second Amendment and state analogs. So he was looking at that himself as Heller having approved what he called a slew of gun laws, including concealed weapons bans based on text, history, and tradition. But moving forward, I think whether we accept this notion that it was about, armed to the terror of the people and public safety, another thing that Judge Kavanaugh said was, the text, history, and tradition test can be applied by analogs as we have modern weapons and different types of circumstances in which those weapons should be used. And one of the things our brief, and this brief was on behalf of former national security officials from across the entire national security apparatus. So we're talking about the Defense Department, the State Department, the Department of Homeland Security, the Department of Justice, the FBI, the intelligence community, the CIA, et cetera, all coming together to just make sure the court is aware of the danger, today of concealable weapons to national security and public safety. And I would take issue with what Professor Leiter said when he said the danger is we understand the danger of handguns when it comes to single murders or violent crimes that involve one or two people. That is undoubtedly true. Our gun violence problem is just, off the charts in this country. But concealable handguns have also been responsible for some of the most atrocious mass shootings, whether we're talking about mass shootings here in the US that were committed by those who were pledging allegiance to a foreign terrorist organization. So the Pulse nightclub shooter, Omar Mateen, used a Glock 17.9 millimeter semi-automatic pistol, among other weapons, to shoot, as we know, 49 people at the Pulse nightclub. In 2019, a Saudi military pilot also used a Glock semi-automatic pistol to kill 8 people, or kill 3 people, injure 8 people at the Naval Air Base in Pensacola, Florida. And if we talk about domestic political violence, white supremacist violence, Dylan Roof used a a 45 caliber Glock semi-automatic handgun to kill, to slaughter 9 parishioners in Charleston, South Carolina, based on his desire to start a race war. Robert Bowers used 3 Glock 357 handguns to shoot 11 people at the Tree of Life Synagogue in Pittsburgh. So my point here is, and I think nobody would disagree, that handguns are responsible for a massive amount of violence in this country. And so as we think about text history and tradition, we think about regulation of carrying weapons in public, particularly concealed weapons, which is what this case is about. The danger of concealable weapons is something the court absolutely has to take into consideration.
May I add one thing to what Professor?
Yeah, go ahead, Rich.
So in the free exercise case last year in Fulton, Justice Barrett, joined by Justice Kavanaugh, said, before we replace the state of the current law, we have to know what comes next. And one of the reasons, and this goes to Mary's point, so we can say lots of things about guns don't do this or guns don't do that, and therefore there isn't as much risk today. Take a look at but we're operating under regimes that ban guns in public places today. They either ban guns like New York does, or they ban guns with what I call location restrictions. So take a look at January 6th in the District of Columbia. The District of Columbia has some of the broadest. It does not have a proper cause requirement because that was struck down by the DC Circuit. So instead, it adopted some of the broadest place restrictions in the nation, including barring guns at or near protests, barring guns in this broad area called the Capitol grounds, which includes all of the mall, barring guns near the White House, barring guns on public transit. So on January 4th, the DC police chief said, the people coming on January 6th, don't bring your guns to Washington, DC. And people who've been arrested for rioting on January 6th in seeking bail and in seeking lower sentences have said, look, I didn't come to DC to break the law. I was caught up in the moment, and the proof of that is I left my guns at home. Now, fast forward to January 6, 2024, or 2028, or whatever, or the next Black Lives Matter demonstration. Under the position we are hearing from the other side, they have a constitutional right, both sides, protesters and counter-protesters, to bring guns to protests. Now, where is there any statute in the founding era or the English era or Knight's case or anything else that supports that? So they attack the New York statute as too broad, but to ask Justice Barrett's question, what would they replace it with? If you read the original petitioner's brief, it was you can carry wherever and whenever. That's on page 29 and page 30 of their brief. If that's the standard, I will probably live long enough to see a January 6th with armed protesters on the Capitol Mall. And that is far too high a price to pay because somebody misquoted a statute back in 1686.
Okay. Now, look, what I want to do is I want to go to Bob, to get your thoughts. And then Robert and Rich, I want to, again, you disagree very strongly about the history. What I want to focus on next is kind of, is there a justice or justices that you're writing in your amicus briefs for? And then, I'd like to talk to Bob and Mary about, who do you think is in play in this case? Okay. But let me go to Bob. So Bob, your reactions?
Yes, my reaction is I think that both Mary and Richard may have more faith in the ability of law to control people's behavior, particularly violent and extremist people, than I do. I think, is a mass murderer going to be deterred because there's a law prohibiting concealed carry or restrictive licensing with respect to concealed carry? Is somebody who is seriously intent on overthrowing the government going to refrain from bringing a gun to the affair simply because there's a statute somewhere? No, that just doesn't comport with human nature, at least as I know it. The case has to lie elsewhere because certainly somebody who was, if we simply take a case of somebody who's seriously determined to commit mass murder, Dylan Root perhaps in search of a race war, would he have been stopped because there was a concealed prohibition on concealed carry? He's doing an act which in the state in which he did it calls for the death penalty, and he's going to refrain from carrying an unlicensed weapon because he might get 5 or 10 year sentence. That just doesn't make sense.
So again, so I think that's, as we're looking at kind of the different positions that the panel is taking, I've been focusing a lot on the history, right? But I think another, striking divide is on kind of the efficacy of, regulation of, they're carrying concealed weapons, where again, we're seeing a split on that issue as well.
Well, could I just very briefly, part of one of the things I think that we have to look at with the Second Amendment is there is a belief that whatever it was meant to mean, it's something of an anachronism, and therefore we have to adopt to modern times and modern circumstances. And I think, my default position is if you think a provision of the Constitution is outmoded, then you should push for its amendment. But even putting that to one side for the moment, if in fact we're going to ask questions about the consequences of certain Second Amendment doctrine, then we have to ask questions about what is the efficacy of various control measures. Do they in fact work? That has to be introduced into the conversation.
Right. So you're pointing out that, it's not just, on one hand, it may be that weapons are much deadlier than they were in 1791, but you were also saying you can't just focus on that. You also have to think about, how effective are the regulations in terms of saving life. So again, I think this is really very thoughtful, fascinating conversation with the positions on both sides. Now, I'd like to move to kind of the predictive mode and the argumentative mode. So let me go back to you, Robert. Who are you writing for, and who do you think is in play? And why do you think your arguments will move one or more members of the court?
So I think we're writing for the originalist justices on the court. The three liberal justices either dissented or I'm pretty certain would have dissented in Heller if they had been on the court. I don't think there's any chance that they're going to vote vote against the New York law. So we're really just talking about the 6 conservative justices. And at this point, I think the issue is these are justices who most of them are originalists and most of them consider themselves bound by the original understanding, whether they politically agree with the result or not. And so I think why you see this bevy of briefs talking about text history and tradition is because you have justices at the Supreme Court who are like Judge Bybee on the Ninth Circuit, who may be very conservative politically, but who nevertheless, because they feel themselves bound by text history and tradition, might go the other way. And here you have a history that is not perfectly uniform in all respects. There are complications which have been fleshed out in the brief. And so I think that's where the battle is at this point, is over those justices who are originalists and who don't and who aren't just following where they think politically it should go. Why my brief? I wrote my brief because I thought that the history on the other side was bad, that it had taken some statutes totally out of context. And not only out of context, both of what they were factually, but also out of context in terms of why we should care about them. So, for example, the main part of the brief, half of it was on these surety statutes in 1836, Massachusetts surety statutes that authorized in some cases that defendants would have to post a bond if they were caught going armed without reasonable cause to fear injury or breach of the peace. And I think here there are three issues or two issues. One is, are they relevant for constitutional interpretation? And the second is, what did these statutes actually do? And so my brief was an attempt to rebut the notion that these statutes actually had some sort of real world effect. And it was also an attempt to talk about constitutional interpretation, because I think a proper text history and tradition text just doesn't take a kitchen sink approach and say, oh, I found this one statute, there it is. Like, you wouldn't ask 100 years from now how we viewed the right of sexual reproduction and autonomy by saying, oh, Wisconsin still had a statute on the books against adultery. Anyone who's living now knows those statutes are in desuetude, and if they were even enforced, it's not clear that they would be constitutional. And so my brief was aimed at both rebutting what I thought were the false historical premises, but also trying to talk about how we're supposed to look at text history and tradition when we're engaged in constitutional interpretation.
I mean, Justice Stevens wrote really an originalist dissent in Heller, but you don't think that and I actually think it was quite a strong opinion.
I think it reads very well. I don't think it was actually substantively that good. And the reason I don't think it was that good is, although he was engaged in, it was kind of a false dichotomy that either the Second Amendment applies to personal self-defense or it's not an individual right. And where I think Justice Stevens went wrong was actually in this early 1990 case called Perpich versus Department of Defense, where he was not able to settle on a consistent understanding of what the militia was. And so, there are he treats the militia, he gives a definition of the militia first as part-time troops, but then he treats them as though it's the state army. Like, you have a governor and a federal president, you have the militia as the state army, and then the standing army as the national army. And his opinion is actually driven by this equivocation on what the militia system is. And so he never actually explains in Heller, even if the Second Amendment is not about individual self-defense, just accepting that for the sake of argument, he still never explains why an individual right to bear arms does not further the military-related purposes that the Second Amendment was designed to protect. So I don't, anyway, sorry. So I don't think...
But you don't see the three liberals as being moved at all by originalist argument. And then just one follow-up question before I go to Rich. So of the six, the conservative wing, are Roberts and Kavanaugh the ones that you're most worried about?
Kavanaugh seems stronger to me based on his Heller 2 dissent. Roberts, obviously, it was in the press that he told the other conservative justices not to grant this earlier, because it only takes 4 to grant certiorari, and they have, it seems that they had 4 long ago, and so the rumor was that he told them not to, that he might not be with them. I also worry about Justice Alito. Justice Alito is not an originalist. His single principle of constitutional interpretation is that he hates criminals. And, here you have a law that could potentially weaken some of the gun control regime. Justice Alito is a prosecutor from New Jersey. He's not, I don't think that he's heavily, my guess is that he's not heavily on the Second Amendment bandwagon, and I could see him going the other way too.
Okay. Rich, who are you writing for?
Well, I think that everyone who is a textualist is in play, with the exception of Justice Thomas, because he's already written a dissent from denial of certiorari, where he said there is a constitutional right to public carry. Interestingly, no one joined that part of the dissent. Kavanaugh only joined the part of the dissent which said we should grant cert, and Gorsuch had joined an earlier dissent from cert on this issue, but didn't join that dissent from cert. So I think everyone who's a textualist is in play, and so we wrote our brief for textualists. And if I can make one point in that regard, the whole premise of originalism is that the founding generation were textualists. Not that they went searching pre-Westlaw, for buried opinions or some commentator who says one thing in one sentence and the exact opposite in the next sentence. And I think here the justices will look at the texts, not what I say about the text, not what Professor Leiter says about the text. They'll look at the Northampton statute, they'll look at the texts that are cited in the SG's brief, the 1541 English statute, the two royal proclamations, and they'll look at the American statutes, and they will see a lot of statutes that have a lot more in common with New York statute than with the reading of statutes based on Knight's case, which itself misquoted the statute. So we were writing for the textualists.
Okay, not Alito?
I agree with Professor Leiter. I think Alito is in play. He didn't join either of Justice Thomas's dissents from denial of cert. So I fully agree. And I think, I think the most likely swing votes are Roberts, Barrett, and Kavanaugh. And Barrett in particular, because in Cantor, Barrett said the strongest support would be laws. Not the strongest support would be the common law. Not the strongest support would be a judicial opinion that misread a statute. Not the strongest support would be commentators who go both ways. The strongest support would be statutes. And so I think Justice Barrett is very much in play.
Okay. What do you think? Let me go to Mary and then Bob. Mary, who's in play? And what arguments are they going to be persuaded by?
Yeah, it's so tough because we only have 3 justices remaining who were on Heller, and so I am oftentimes loath to engage in speculation. But I also agree with Richard. I mean, looking at Justice Barrett's dissent in Cantor, that was a very different case. That was about a classification of felons, even nonviolent felons, as being ineligible for possessing firearms under federal and state law, and she markedly put that in a different category from restrictions on types of weapons or on activities. So to me, if she looks at concealed carry as an activity, and she was very clear in her dissent also to put paramount the public safety interests, I think that means she is somewhat in play. I would say the same with respect to Justice Kavanaugh, who we know does not believe any type of scrutiny analysis should be applicable. He made that very clear in his dissent in Heller 2, that he believes it's all text, history, and tradition. But he also was very clear that the way that applies is we do look to these longstanding restrictions. And I think there's substantial meat there on what's longstanding, particularly when it comes to these things. Obviously, I think the chief is somebody that we're trying to speak to in our briefs, and I think in the brief that we wrote at ICAP for the national security community was really also about, to be honest, was about containment, right? So if the issue that ends up that I know that the petitioners are really trying to get the court to focus on is less about these particular restrictions on concealed carry licenses, which is about requiring good cause, some sort of cause to get a concealed carry license. They're trying to make the question really about, is there any right to carry in public? And they're doing that by saying, look, in New York, because you can't open carry, and a lot of people, at least according to them, although the state disputes this, can't get a concealed carry license, that is functionally a complete ban on any carrying in public. And so I think part of this will come down to how does the court want to look at the question and how broadly they want to look at the question. We know from Thomas's dissent in Peruta v. California, along with Gorsuch, he thought the important question for the court to resolve is that question, right? Is there a right to carry in public, period? Not this question about, is there a right to concealed carry? So I think part of what at least I was trying to do in writing for the national security community is make clear that there is a significant national security and public safety interest in regulating the carrying in public of firearms. They are attributable to massive amounts of gun violence in this country. And although I totally understand, agree with Professor Cottrell that a criminal is not going to be swayed by whether there's he has a license or not. If he's hell-bent on going and committing a mass shooting, he's going to try to do that. But statistics show that there are increases in gun violence when there are laxer gun regulations, that they're, including places, Arizona, for example, it changed its laws. There's, real demonstrable statistics that show how that impacts the amount of gun violence in those communities. And I also think that when we are talking about mass events, I think Professor Bernstein mentioned January 6th. He mentioned, racial justice demonstrations and protests. The more people, and there's statistics on this too, the more people that are armed, the much greater, I think something like 60% greater potential for violence at those types of events. So in target-rich environments, New York City, Washington, D.C., major cities, and in places where you're going to have people whose views are opposing views, the ability for law enforcement to have the flexibility to regulate guns in those situations, I think is something that will be appealing to the justices, including the conservative justices. And so that's part of, what our focus was in terms of that reality. And I understand the efficacy point, but I think there's some, statistics do bear out that gun regulations do have an impact.
Okay. Bob, your thought on who's in play and what will persuade them?
My thought right now is Justice Roberts being in play, that one of his concerns is going to be, I guess, the institutional reputation of the court and to what extent, how his vote will impact that one way or the other. I'm not sure of the others, frankly. Well, let me just let it rest at that for the moment.
Okay.
Mm-hmm.
We got 5 minutes left, and this is a great discussion. So you got 1 minute each, and I want, how's it going to come out, and what's your closing thought? So Rich, Robert, Bob, and Mary. So Rich?
There is no originalism without textualism. Look at the texts, both in England and in the United States. And they support not only the New York law, but all the location restrictions in places like DC and otherwise that will be struck down if the New York law is struck down. So I think we will win. I also think there are enough Jacksonian conservatives left. And by Jacksonian, I mean Robert Jackson, not Andrew Jackson. And as Robert Jackson made clear in the Terminiello case, while laws don't stop a determined mass murderer, maybe, they stop the ordinary person who is subject to rage or incitement at a given moment. And I don't think the Supreme Court will take on its shoulders the responsibility of saying all those people who have moments of rage, political protests, or mass rage or rage are constitutionally allowed to have, no matter what any legislature thinks, guns on their hips in all public places at all times.
Okay. So Rich, New York's saying New York is going to win. And at the end of the day, it's both textualism and the court's concern about public safety that will drive that result. Robert?
So I think, let me start off by clarifying the issue here, because I think we've gone off the train a little bit. The issue is whether there is a right to bear arms in public at all. It is not about whether, if there is such a right, that the government is somehow barred from engaging in any regulation of the right. The question is not whether you can bring your guns into the Capitol building or to a public demonstration. The New York Sullivan law applies in all places and at all times. It applies from Times Square all the way to the mountainous areas of New York. And so the only thing that the court really has before it is whether there is a public carry right at all. It is not answering the other stuff about whether you can ban guns in sensitive locations or restrict the manner of carrying weapons. In terms of a prediction, I think that they will issue a very narrow opinion, and it will be a narrow opinion in one of two ways. They will answer the question about whether there is a right to bear arms in public affirmatively, and then say, look, all we're saying is that New York went too far here. but it's still subject to substantial regulations. See Heller's discussion of restrictions on concealed weapons in sensitive locations. Or I think the Chief Justice may be trying behind the scenes, to come up with some sort of very, very narrow opinion that says that New York's proper cause requirement is being enforced in an arbitrary and capricious way. So I wouldn't be surprised if we get some kind of opinion that doesn't look like something that we're thinking about going into this case. But I still think, giving that prediction, I still think there is a substantial minority chance that New York wins the case outright. I don't think it's likely, but I do think it is possible.
Okay. Thank you very much, Robert. Bob, closing thought and prediction.
Okay. My prediction is that New York loses, that in fact the licensing scheme is overturned. And I think that one of the things that I would like the court to do, I'm not saying that it will, is to consider not only the Second Amendment implications of this, but the 14th Amendment. The New York State licensing law started with an anti-Italian animus against Italian immigrants. It's moved on to be enforced in a discriminatory manner against others. I've noticed the brief from the Bronx legal aid attorneys who represent mostly Black and Hispanic clients, who've noticed the degree to which there's been tremendous discrimination in the enforcement of the statute. As they said, as a result, each year, we represent hundreds of indigent people whom New York criminally charges for exercising their right to keep and bear arms. For our clients, New York's licensing scheme renders the Second Amendment a legal fiction. Worse, virtually all of our clients whom New York prosecutes for exercising their Second Amendment rights are Black or Hispanic, and that is no accident. New York enacted its firearms licensing requirements to criminalize gun ownership by racial and ethnic minorities. That remains the effect of its enforcement by police and prosecutors today. The consequences for our clients are brutal. New York police have stopped, questioned, and frisked our clients on the streets. They have invaded our clients' homes with guns drawn, terrifying them, their families, and their children. They have forcibly removed our clients from their homes and communities and abandoned them in dirty and violent jails and prisons for days, weeks, months, and years. They have deprived our clients of their jobs, children, livelihoods, and ability to live in this country. And they have branded our clients as criminals and violent felons for life. They have done all this only because our clients exercised a constitutional right.
Well, thank you very much, Bob. And that's a powerful point that the brief makes. And it really, that's really been one of the themes of your scholarship, which has been path-breaking, about the kind of the unequal application of these restrictions in a way that has really hurt Black Americans. So thank you for bringing that point up at the end. Mary, prediction and closing thoughts.
I am going to be a little bit vague in my prediction and say whether the court upholds New York's law or not, I think it's going to remain the case that many, many gun regulations will still stand. I think the court will be clear and reiterate what it already held in Heller, that many gun regulations are perfectly consistent with the scope of the Second Amendment. And so we'll not be opening the floodgates for challenges.
Well, I have to say, this is a critically important case, I think, and I can't imagine a better panel. These were really fabulous, fabulous thoughts and insights, and I want to thank you for your time. I learned a lot, and I want to thank all of our participants for watching us. So, and the argument will be November 3rd. So we'll find out what the arguments made before the court are then, and we'll await the decision. So, but thank you all very much. Take care.
Thank you.
And thank you, Debbie, for helping bring us together.